Islamic international law, or Siyar. The overview of Siyar, the definitions and scope of Siyar, sources of Siyar versus contemporary international law, historical development of Siyar, al-Shaybani's contributions to Siyar, comparative analysis, al-Shaybani and Western jurists, significance of studying Siyar in the modern era, and the conclusions. Islamic international law, known as Siyar, is a crucial yet often overlooked aspect of both Islamic jurisprudence and international legal studies. This presentation is to elucidate the concept of Siyar, its historical development, and its relevance in the contemporary global legal landscape. It explores the contributions of prominent Islamic scholars, particularly Muhammad ibn al-Hasan al-Shaybani, and compares Siyar with Western conceptions of international law. The term Siyar is derived from the Arabic noun sirah, plural for siyar, which literally translates to path or way of walking. In the context of Islamic jurisprudence, siyar refers to the corpus of rules and regulations that govern the relationships between a Muslim state and other states, Muslim individuals and non-Muslim individuals or entities, Muslim states and non-Muslim individuals or entities. These rules apply both in times of peace and war, encompassing a wide range of international relations. The scope of Siyar is extensive, covering various aspects of international relations and the law. The key areas include jihad, the use of force, rules governing the legitimate use of force in Islamic law, aman, safe conduct, the principles of granting protections to non-Muslims in Muslim territories, treatment of prisoners of war, regulations on the capture, detentions, and release of enemy combatants, rules of ransom, guidelines for the exchange or release of prisoners, spoils of war, distributions and management of assets acquired during conflict, war crimes, definitions and prosecutions of offenses committed during warfare, rights of those granted asylum, the protections afforded to individuals seeking refuge in Muslim lands, diplomatic relations and envoys, protocols for international diplomacy and the treatment of foreign representatives, international and transnational property law, regulations governing ownerships and transfer of property across borders, treaty law, principles for the formations, interpretations, and terminations of international agreements, international trade law, rules governing commercial transactions between Muslim and non-Muslim entities, rights of religious minorities, protections and obligations of non-Muslim communities in Muslim majority states. Siyar, as a branch of Islamic law, Sharia, derives its primary sources from the Holy Quran, the central religious text of Islam, the Sunnah, the traditions and practices of the Prophet Muhammad. Islamic jurists have constructed their legal reasoning based on the fundamental principles derived from these divine sources. Additionally, they employ secondary sources and methodologies of Islamic jurisprudence, which includes qiyas, analogical reasonings, the process of applying a known injunction to a new circumstance by establishing similarity in the effective course, ijma, consensus, the agreement of Muslim jurists on a particular issue in a given age. While Siyar shares some commonalities with modern international law, there are several key distinctions. The first is the sources of law. Siyar derive primarily from divine sources, the Quran and Hadith, Contemporary international law, however, based on secular sources such as treaties, customs, and the general principles of law. Siyar applies specifically to Muslim states and individuals in their interactions with non-Muslims. Contemporary international law, however, aims for universal applications to all states and international entities. Siyar evolved from the 7th century onwards with significant contributions from early Islamic jurists. Contemporary Islamic international law, contemporary international law primarily developed from the 17th century with roots in European legal traditions. Siyar is based on Islamic principles of justice, equity, and the unity of the Muslim community, the Ummah. Contemporary international law founded on principles of state sovereignty, equality of states, and pacta sunt servanda, agreements must be kept. During this era, the basic principles of Siyar were established through the first is the practices of the Prophet Muhammad, the policies of the rightly guided Caliph, and the expansion of the Islamic Empire under the Umayyad dynasty. This period saw the systematic codifications and elaborations of Siyar by prominent jurists. Abu Hanifa, the founder of the Hanafi school of Islamic jurisprudence, Al-Awza'i, Syrian jurist who wrote extensively on warfare and international relations. Muhammad ibn al-Hasan al-Shaybani, the author of Al-Siyar al-Kabir, a seminal works on Islamic international law. During this time, Siyar continued to evolve through the works of later jurists who built upon and refined earlier principle, the practices of Muslim states in their interactions with non-Muslim powers. The advent of European colonialisms and the decline of Muslim political power led to challenges to the traditional applications of Siyar. Attempts to reconcile Islamic legal principles with modern international law. Muhammad ibn al-Hasan al-Shaybani is widely regarded as one of the most influential figures in the development of Siyar. His magnum opus Al-Siyar al-Kabir, the major work on international law, represents a comprehensive treatise on Islamic international law. Systematic codification, Al-Shaybani organized and systemized the existing rules of Siyar, providing a coherent framework for understanding Islamic international law. Comprehensive coverage, his work addressed a wide range of topics including rules of warfare, treatment of non-combatants, diplomatic immunities, treaty obligations, and international trade regulations. Legal methodology, Al-Shaybani employed rigorous legal reasoning, drawing upon Quranic verses, prophetic traditions, practices of the early Muslim community, and logical reasoning or qiyas. Influence, Al-Shaybani's work became a foundational text for subsequent generations of Islamic scholars, shaping the development of Siyar for centuries to come. Al-Shaybani and Western jurists, to fully appreciate Al-Shaybani's contributions, it is instructive to compare his work with that of prominent Western jurists who shaped the development of international law in Europe. These comparisons, there are 5 of them: Saint Augustine, Gratians, Thomas Aquinas, Francisco de Vitoria, and Hugo Grotius. His writings often included hypothetical scenarios and case studies demonstrating the application of legal principles to real-world situations. St. Augustine's the temporal context. St. Augustine predates Al-Shabani by several centuries, writing in the context of the late Roman Empire. Augustine's concept of just war laid the foundations for later Western theories on the legitimate use of force. While Augustine focused primarily on the moral justifications for warfare, al-Shaybani provided a more comprehensive legal framework governing various aspects of international relations. Gratian's work in the 12th century represents the systematizations of canon law in medieval Europe. His Decretum Gratiani included sections on just war theory and the treatment of non-Christians. Both scholars sought to systemize existing legal principles, but al-Shaybani's work was more focused on international relations and predated Gratian by several centuries. While both scholars drew upon religious principles, al-Shaybani's work was more directly focused on practical legal issues in international relations. St. Thomas Aquinas wrote in the 30th century during the High Middle Ages. He further developed just war theory and addressed issues of natural law. Francisco de Vitoria wrote in the 60th century during the early modern period and the age of European explorations. He addressed issues of colonialisms, the rights of indigenous peoples, and the concept of jus gentium, the law of nations. Both scholars demonstrated a humanistic approach to international relations, but al-Shabani's work predated Vitoria's by over 7 centuries. Hugo Grotius wrote in the 70th century during the formations of the modern state system in Europe. It is often called the father of international law. Grotius systemized and secularized many principles of international relations. While Grotius is widely credited in the West for establishing the foundations of modern international law, al-Shabani's earlier work demonstrates that many of these principles were already well developed in Islamic jurisprudence centuries earlier. The study of Siyar holds considerable importance in the contemporary global context. It provides a more comprehensive and inclusive view of the development of international law, challenging Eurocentric narratives. Siyar's emphasis on the rights of non-combatants, prisoners, and minorities can contribute to ongoing discussions on human rights and international law. Understanding Siyar can facilitate better communications and cooperations between Muslim majority states and the broader international community. Siyar offers alternative perspectives on international legal issues, potentially enriching global legal discourse. Knowledge of Islamic legal principles can aid in resolving disputes involving Muslim majority states or communities. Islamic principles regarding the stewardship of nature could inform international environmental law. Islamic international law, Siyar, represents a sophisticated and comprehensive system of rules governing international relations from an Islamic perspective. The work of scholars like al-Shaybani demonstrates that many principles of international law were well developed in the Islamic world centuries before their articulations in Western legal traditions. As the global community grapples with complex international challenges, a deeper understanding of Siyar can contribute to more inclusive and effective approaches to international law and diplomacy. By bridging the gap between Islamic and Western legal traditions, we can work towards a truly global framework for international relations that respects diverse legal and cultural perspectives while upholding universal principle of justice and human dignity. Al-Shaibani's book Al-Siyar al-Kabir addresses every conceivable aspect of international law relevant to his time. Despite being rooted in Islamic law, its comprehensive nature makes it a significant asset for specialists in international law today. Al-Shabani is recognized as one of the earliest and most important contributors to international law. Despite several attempts, English literature still lacks comprehensive studies on al-Shaibani's work. Legal historians often overlook the period between Roman era and modern times, neglecting nearly 1,000 years of legal development. This gap includes the significant contributions of Islamic international law, which governed the international relations of Muslim states for centuries. The principles of Siyar were advanced and comprehensive, yet they have been marginalized in historical accounts. There's speculations about whether European jurists like Vittoria and Grotius were influenced by Siyar, given the extensive translation of Islamic literature into Latin. The proximity of Islamic civilizations in Spain to these jurists suggests they might have been aware of Islamic legal principles. The lack of recognition of Siyar's contributions is partly due to the scarcity of original studies. Scholars like Janice argue that Islamic jurists need to make the legal system better known. This